Okay, we all ready to go, folks?
Yes, Your Honor.
Then I am calling State of Wisconsin versus James Prokopovitz, and this is file number 2019 CF 716. May I have the appearances, please?
Deputy District Attorney Wendy Lemcool and Assistant District Attorney Caleb Saunders, as well as Sergeant Roman Ehrenstein of the Brown County Sheriff's Department and Special Agent Jay Yurgis of the Wisconsin Department of Justice, Division of Criminal Investigations, all appear on behalf of the state.
Thank you.
Your Honor, James Prokopovitz appears in person, being assisted by Attorney John D'Angelo, as well as counsel table is my paralegal Bonnie Gottfried.
Thank you. We just have a number of things before the jury comes out. It's 25-2, so all the jurors are present, and so we'll take those up. First of all, when the jury comes out, we do have to swear the jury. We will do that. Secondly, I will reread instruction number 50. I read that Friday afternoon or Friday morning, and then we'll have to read it again. Thirdly, we talk about sequestration. I have, well, before I do that, Ms. Lenko, go ahead. Did you want to say something?
Thank you, Your Honor. Yes, the state did file a document, a decision on order on motion, motion clarifying a decision that had previously been made. There had been, the state's understanding was a motion filed with the court previously about allowing the two daughters, specifically Stacy Deere and Marcia Loritz, to be excluded from the sequestration order. As the state is familiar with and the state of Wisconsin acknowledges, it's the state's understanding that the victims have the right to participate in proceedings outside of the traditional order, particularly not only Chapter 950, which is the victim rights legislation in Wisconsin, but in addition, under Marcy's law, a newer law here in Wisconsin in the last year. Based upon that, we had previously requested the court to make a finding that they would be outside the sequestration order at that time. And we even included in our motion a statement by Attorney D'Angelo where he specifically addressed on the record, and that's on page 3 of the motion. You said, do you have an objection to them, in reference to them being here? Counsel, Mr. D'Angelo, no objection, Your Honor. And you said that's even in spite of them being witnesses. And Attorney D'Angelo said, understood, Your Honor, I do have their testimony, blah, 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 the rest of it. With respect to that motion for clarification, Your Honor, we did have contact with Mr. D'Angelo, as is always a defendant's right. Mr. Prokopovitz could contest the presence of the daughters in the courtroom and indicate that he doesn't believe it would be appropriate, although it is the state's position and clearly victim witness that the law allows this. It's my understanding, Mr. Prokopovitz, his position is that he's objecting to them being in the courtroom outside of the sequestration order. Again, state understands he has the right to object. It's still, for the record, is our position that it could be construed as a victim rights violation if they are not allowed to be in this courtroom and listen to the evidence as the court. And the court, I believe, that is our position, and we understand that because some of these areas under the law have been a little gray with respect to Marcy's law, that we're all navigating through that, but we are expressing our position that they should be allowed to be in the courtroom, Your Honor.
Thank you, Mr. D'Angelo.
Thank you, Your Honor. The recitation of what happened at the last hearing with regards to this issue is accurate. I did speak to my client over the weekend with regards to this issue again as it came up. Based on the court's decision on Friday to exclude them as part of the sequestration order, I spoke to my client with regards to that. On Wisconsin statute 906-15 sub 2 sub D, it still does provide that a criminal defendant can have witnesses excluded if it's found to be necessary for the fair trial of the defendant. My client is requesting that it be done so for a fair trial based on the fact that I understand that there was previous proceedings in which testimony was taken. However, there was also multiple police interviews, investigative interviews with all the parties, and some of that testimony isn't exactly covered in the previous proceedings. And also the fact that in those previous proceedings, Your Honor, there wasn't an opportunity for cross-examination. So my client is asking that the parties be excluded pursuant to 906-15 sub 2 sub D.
Thank you. Ms. Lemko, anything else you'd like to say?
Well, Your Honor, just kind of what's outlined, this was a previous ruling, the state relied on it. We believed that they would be able to be in the courtroom. We did move our witness order around that, which we like to just do things typically in order with time sequence. I am indicating, and I know Attorney D'Angelo knows the law, that a constitutional right would trump the statutory interpretation. So that is the state's position with respect to it. We think they should be allowed to be in the courtroom, that they have that constitutional right.
Thank you very much. And before we go on, we do have the two officers, the investigative officers. You did not have an objection to them, correct, Mr. D'Angelo?
Correct, Your Honor. I think pursuant to the statute, again, there is a specific exclusion for investigating officers, and the two officers would be allowed to participate and sit at council table.
So they are not part of the sequestration order. And then I did look at the handout given to me by the district attorney's office, and this is on page 11 of 18. It reads, the amendment in Marcy's law related to victim appearance removed previous language that allowed the court to sequester victims if the court found sequestration necessary to a fair trial for the defendant. Wisconsin statute 906.15 paren 2 paren D still provides that a victim in a criminal or juvenile case may be excluded if the court finds exclusion, quote, is necessary to provide a fair trial for the defendant or a fair fact-finding hearing for the juvenile, period, close quote. However, this section of the statute could be modified in the future as a result of the efforts to harmonize the existing statutes and Marcy's law. So based upon that, I am going to, the sequestration order applies to everyone except those persons at the table here. That's why they are not in the sequestration order. I am going to sequester everyone else. I have looked at section 906.15, exclusion of witnesses. I'm looking at D, and I am making a finding that exclusion is necessary to provide a fair trial. For the defendant in this case, for the reasons outlined by Mr. D'Angelo. I do recognize that earlier, Ms. Lemko or Mr. Saunders is correct. The motion for clarification at the hearing on January 15th, 2021, they were not excluded. However, I did inform the parties on Friday, last Friday. So this doesn't come as a surprise that this is what I was going to do. So if you have, you order your witnesses, etc. I told everybody Friday just what we're going to do, and that's what we're going to do. I think there's a lot of, as Ms. Lemko said, a lot of gray areas, and this is one of them, I think. But the law does allow me to make that finding, and the part I did read is it could be modified in the future. It has not been modified yet. And I do think it's necessary for the sequestration order to have effect for everybody to provide Mr. Prokopovitz with a fair trial. So saying all that, with anybody, the sequestration order takes effect after the opening statement, and then until that person testifies. So what I am willing to do is if the state would like to call a person out of order so that they could testify and then attend the hearing after that, they can do so. And Mr. D'Angelo told me off the record that he has no objection, so we can do that. But that's up to the state to decide the order of their witnesses.
Your Honor, I can advise the court we were fully aware of what you told us on Friday and had approached Attorney D'Angelo about a stipulation regarding that. That's when we were aware that the defendant was opposing this. With respect to that, we're ready to go. We were aware of it, so we have no problem. We're ready to proceed.
And thank you for making a record, and hopefully I made a record too, as to why the sequestration continues. If Mr. Saunders or Ms. Lemko, if you are going to take people out of order in an effort so they can attend the trial after they testify, you certainly could do that. Is there anything else that we need to go over before we call the jury out? I do recognize that we're in the middle of a terrible pandemic, COVID, and we're all wearing masks, and I would ask everyone to wear a mask. I would also ask everyone to socially distance, except if you're part of the same bubble, so to speak, then of course you don't have to, but otherwise, we're limited in the number of people in this courtroom to 30, and we will respect all the CDC recommendations as well.
Senator, from the
Yes.
state's perspective, we have one other issue to address. As the court is aware, we did file another document with the court. It was related to the media coverage of this case. It is a 2-page document. I did have discussions with Attorney D'Angelo with respect to it, as well as a representative or producer, I believe, from Court TV and some of the other media. They have been very respectful with the parties. We had been given prior notice of their presence here, and the court had put us on notice as well. We've worked with Attorney D'Angelo with that. We've also spoken to them. One of the concerns that the state had was just making sure that there was nothing that would infringe upon a defendant's right to a fair trial with respect to any conversations being picked up with him and his counsel. We don't need an appellate issue with respect to that, as well as anything related to the state, meaning our tables, our laptops, anything like that. We did speak to a representative who was here this morning, and again, they've been wonderful with respect to putting us on notice. However, we need to just focus on trying the case and preserving the integrity of this prosecution and case. So we did file that document. I think all parties are in agreement with respect to it. And we've been advised by all media representatives that they will. I presume that the court is going to be accepting the request of the parties in that February 13th letter that we did file.
Yes, I am accepting this as well. And just changing topics here very quickly, the prior bad acts, does anybody have any questions about those? What is going to be admitted, what's not going to be admitted? Because when the jury comes out in closing, if they're referred to, I want to make sure we get it right so we don't have a problem right away.
Thank you, Your Honor. I do believe there's a clarification that both parties, there had been a discussion between the parties, in particular on one area. And I think what that was is the court had previously indicated that in the incident involving the gun that the defendant allegedly held to the head of his daughter, Lisa Maste, we believe that the ruling that came from the court was going to be that that there was going to be testimony admitted through Darlene Ingalls. It could be admitted. The incident also happened to Lisa Maste, and I think the parties were just wondering about the clarification of that. So it would be able to be testified to by the bystander of it, as opposed to the person that it was happening to at the time. And we determined maybe the court's finding with respect to that was Darlene was the former wife of the defendant, and that's why it was being permitted to come in through her.
Well, Mr. D'Angelo, anything you'd like to say on that?
Yes, Your Honor. I think I relate to the sentiments of the state. We're just looking for clarification is if Ms. Mastay is not going to be able to testify at, whether or not Ms. Ingles testifies to it or not. I think my understanding, and I think the state's alluded to, is the idea is that because she was the former wife, that was the reason why she was allowed to testify, but because Ms. Mastay was not his former wife, but is his daughter, she wouldn't be allowed to testify. So just so we know when we're asking questions and what direction we can go with, I think it would just be helpful just to have clarification on the court's perception of who had the ability to testify.
And then what I did decide was that Darlene Ingalls could testify about that incident because she is the ex-wife, and part of her observations of her marriage included that incident. But Lisa Mastey would not be able to testify for that because it's both cumulative and for her, I mean, it was a long time ago. So it's for Darlene Ingalls only.
Thank you, Your Honor.
Was there anything else with regard to prior bad acts? Thank you very much, and we're ready for the jury then. Let's stand for the jury. Have a seat, everybody. Thank you. You know where Tom went? Okay, ladies and gentlemen of the jury, thank you for coming back here today. We chose a jury last Friday over the KI Center, and we're here today. The first thing I would like to address is the COVID. We do have a great deal of plexiglass up, and we're all wearing masks, and we're socially distancing, and there's only 30 people that are going to be allowed in the courtroom. So we also have hand sanitizer and other products that the bailiff Tom will give you. There are two bailiffs here today. Bailiff Tom is over here, and Bailiff Joe is back there. They will be handling any services dealing with the jury during this trial. So before we get started, I would like to swear you in. Madam Clerk, if you would do the oath, please.
Will all the jurors in this trial please stand and raise your right hands? Do you and each of you do solemnly swear that you will well and truly try the issue joined between the state of Wisconsin and the defendant and give a true verdict according to law and the evidence in court? So help you God. Thank you. You may be seated.
And ladies and gentlemen of the jury, as we go through this process with witnesses, the witness stand is right next to me, by the way. If you can't hear something, just raise your hand. We want to make sure you're able to hear everything and see everything, and let me know, or let Bailiff Tom know, or Bailiff Joe know. Before we get started, I also would like to reread the instruction I read to you on Friday so that you have a better understanding of your duties here during this trial. Before the trial begins, there are certain instructions you should have to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. Do not let any personal feelings about race, religion, national origin, sex, or age affect your consideration of the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented, and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about this case. Do not consult dictionaries, computers, websites, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share information about this case. For example, do not communicate by blog, email, text message, Twitter, or in any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence. It is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide this case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which lawyers have agreed or stipulated or which the court has directed you to find. Attorneys for each side have the right and duty to object to what they consider are improper questions asked the witnesses and to the omission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of credibility of the witnesses and the weight of the evidence. You are not required to, but you may take notes during the trial, except during the opening statements and closing arguments. The court will provide you with materials. In taking notes, you must be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and the testimony introduced during the trial. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show so that you will better understand the evidence that is introduced during the trial. I must caution you, however, the opening statements are not evidence. Thank you. Mr. Saunders, are you all set?
Thank you, Your Honor. Good morning, ladies and gentlemen. $2,854 days. That is the last day that Victoria Prokopovitz was seen alive. She was last seen in her home on Coonish Road over in the town of Pittsfield. The last person to see her husband, James Prokopovitz, the defendant. Her disappearance, ultimately what investigators uncover over the period of their 8-year investigation, is what leads us here today. You'll hear a lot during trial about Vickie, who she was. She was a 59-year-old woman, mother of 3 children, 2 daughters, Marcia and Stacy, a son, Wes, or Wesley. She had several grandchildren. She was born, raised in the Brown County area her entire life, left the state on just a few occasions. She had various jobs. She worked as a secretary, a waitress, in a nursing home, in the deli at Super Ron's Market in Pulaski. She cared for pets, enjoyed baking, making crafts. Ultimately, she married the defendant, Mr. Prokopovitz, in 1989, and they were married for 24 years, until Vickie disappeared 7 years and 10 months ago. This case, why we are all here today and in the next several weeks, is a search for the truth of what happened to Vickie on April 25th, 2013. Again, myself, Attorney Lemkuhl, we represent the state of Wisconsin. This isn't a civil case where we represent Vickie or her family. We represent the people of this state and the people of this community. We work with law enforcement. You'll see seated at council table, Special Agent Jay Yurgis from DCI, Sergeant Roman Ehrenstein from the Brown County Sheriff's Office. They were the 2 main case agents throughout this case who worked this investigation for the past 8 years. You'll hear during the course of testimony and evidence about the day Vickie disappeared on April 25th, 2013. Jim and Vickie, they went to a doctor's appointment earlier that day, about 1 o'clock, 1:30 in the afternoon. Vickie that day was reported to be in good spirits, dressed nicely. This was noted both by her son, Wes, and the defendant. When they got home later that day, they had supper with Wes. Ultimately, a little bit later, about 6 or 7 o'clock, Wes leaves the house, goes to some friends for the night. About 4 a.m. is when he returns to the house, the following day, April 26th. You'll hear evidence and testimony that the last person to see Vickie alive is the defendant. Wes gets home about 4 a.m. He's coming from the city, coming from Green Bay, driving west down Coonish Road. And as he's pulling in, getting home, he sees another vehicle coming from the opposite direction, more from Pulaski, from 32. And it's the defendant, about a little after 4 a.m. And you'll hear Wes, when he testifies, this was odd. It was a little bit earlier than he would typically be up to go to work. You'll hear evidence and testimony that when Wes gets home, immediately the defendant is telling him his mom is gone. Gone. Not missing or not here, that she's gone. The defendant then immediately gets back into his car, drives off, he says to go look again for Vickie, despite just arriving back home. You'll hear he goes to work, and it goes to work as usual. He works for a company called McKeefrey's. You'll hear that a lot. They're a contract, or they had a contract with Georgia Pacific, the plant right over on Broadway here, downtown Green Bay. Clocks in at 5:30 that morning. Again, goes to work as usual. He has contact with several coworkers throughout the course of the day, people he worked with for several years. You'll hear from those coworkers evidence and testimony. He's not telling them, the defendant's not telling them that his wife of 24 years is missing that morning, that she wasn't home. You'll hear from the coworkers that some found out days later through other people He also does not report it to law enforcement that morning. Not until he returns home after work. About 1 o'clock that day on the 26th, he calls law enforcement, reports Vickie missing. Full 10 hours after first arriving home. You'll hear evidence and testimony that officers responded that day and began, at that point, what was a missing persons investigation, not a homicide investigation. Officers immediately begin searching the area. Jim had told investigators Vickie was wearing a stacked heel shoe that morning. That was a shoe that was missing from the home. You'll hear Vickie was not walking long distances at this point due to some physical issues that she had. It's dark at night. So many of the things that are important to Vickie, tangible items, her purse, cigarettes, her cane, dentures, driver's license, phone, all left at the house. She didn't drive, she didn't have her own car. Again, was not walking long distances. So investigators look in the immediate area of the residence. And it's the town of Pittsfield. It's a rural area. The residence they lived in, an old farmhouse, so there's some outbuildings on the property, fields, open fields, creek that kind of goes by the residence. That same day, searchers, canines, and officers who arrive on scene search the area, do not find Vickie. Over the course of the next 8 years, you'll hear from numerous members of law enforcement, of Vickie's family, random citizens, other search organizations, search throughout this area for Vickie. They searched the Mountain Bay Trail, which runs through the back of the property. Dozens of volunteers, people on horseback, searchers using canines and cadaver dogs, using sonar equipment to search nearby quarries. Drones are used to search the expansive fields in the area. Investigators also took other avenues to try to locate Vickie, some sign that she was elsewhere. You'll hear that phone records showed barely any contact with another person, very little contact. Again, no vehicle, no credit cards to her name, didn't have a lot of friends or neighbors that she was close with. Officers checked local hospitals, medical facilities, called local taxi cab companies to see if anyone was near the Coonish Road address. They search Interpol databases. They search contact with law enforcement in all 50 states. No contact with Vickie. No trace of her over the past 8 years. You'll also hear testimony and evidence that during these searches at the house, again, searches where random citizens were showing up to help find Vickie, you'll hear that the defendant did not assist in those searches. You'll hear he, in some occasions, sat in his recliner and was drinking beer. You'll hear that he continued to go to work as usual that day that he found out she was missing, and the days that followed, continued to go to work as usual. The family started noticing this, noticing the defendant's attitude during these searches, that he wouldn't assist, that he wouldn't come out and thank searchers for helping try to find his missing wife. The weekend you'll hear after she disappeared, that weekend, Vickie's daughter, Marcia, is reporting that Jim's telling her he's going to get a U-Haul to come and get this shit out of the house. That he didn't need a place that big just for him. In the weeks that followed, the numerous searches that were done at the residence, searchers are reporting overhearing comments like this. You will never find her. She's not there. You're wasting your time searching that area. The defendant's own daughter, who you'll hear from, Lisa Masty, told officers that the defendant would express anger, that more searches were being done to try to locate his missing wife. Again, at this point, it's a missing persons investigation. You'll hear a lot of evidence and testimony throughout the next several days about Vickie's physical and mental health. You'll hear she was diagnosed with colon cancer in the summer of 2012, had a colostomy bag, ultimately had a reversal of that procedure prior to her disappearance. But due to that, she would use a walker at times, would use a cane to get around, was not walking as usual. You will hear that Vickie had bouts of depression, that she consistently over the years saw psychiatrists. There was not, and you won't hear, evidence of a long history of suicide attempts. You'll hear about 2 instances, none since 2003, 10 years before her disappearance. You'll hear from her psychiatrist who worked with her for several years, most recently in the summer of 2012, just a few months before she disappeared, that he didn't consider Vickie to be suicidal around the time she disappeared. Defendant himself telling investigators he believed that Vickie appeared to be in good spirits that day. As the investigation continues, you'll hear more about information that officers are gaining with respect to Jim and Vickie's relationship. Their relationship was not intimate in at least a year before her disappearance. You'll hear that the defendant controlled a lot of Vickie's life, controlled the medication, controlled the finances, controlled Vickie's access to her medication that she used for her depression. He would do the grocery shopping. He would drive Vickie places. Again, she doesn't have a car to get around. You'll hear from the psychiatrist that Vickie was saying about what she's telling him with respect to the relationship. How Jim was controlling and abusive, in her words. You'll hear from the defendant and various comments that he's making to law enforcement about the disappearance, as if Vickie was some sort of a burden. He's telling officers, quote, "If you would have lived with this damn woman for 20-some years, you know what I'm trying to tell you, what we went through." Said within months of Vickie's disappearance. You'll also hear evidence and testimony that within several weeks of Vickie's disappearance, defendant's asking his employer about removing her from his insurance that he has through his employment, ultimately doing so in September of 2013. You'll hear evidence and testimony then about a conversation that the defendant had with Vickie's children and the family, about a new relationship that he started with a person. You'll hear Kathy Friday, person he knew from years prior. Began calling Kathy within weeks. Vickie's disappearance in May of 13. Ultimately, a romantic relationship commences shortly thereafter. And you'll hear evidence and testimony about how the defendant and Kathy Friday, his girlfriend, are explaining this relationship. That it was a chance encounter in Wittenberg at a casino over in the middle part of the state. Happened upon each other. They were both dealing with, obviously, the defendant having a missing wife, and this relationship starts, and that is how this came to be. They tell this story, you'll hear, for years. They tell it to Sergeant Ehrenstein, they tell it to Special Agent Jurgis, to family members. Ultimately, they tell it under oath during a hearing relating to this investigation. You'll hear that officers spent a significant amount of time attempting to verify this version as it was relevant to their investigation. They're trying to find what happened to Vickie. You'll hear evidence and testimony that Kathy and the defendant ultimately did testify in a hearing and maintained that this Wittenberg casino story is how they met. You'll hear Kathy admitting to getting a second phone so they could communicate without her family finding out about it. You'll hear that the defendant admitted to lying to police for years about how he met Kathy, how this relationship started, admitting that this casino story, them randomly coming into contact with each other, was a complete farce. You'll hear during the course of an interview with law enforcement, the defendant admitted to being involved in Vickie's disappearance. Quote, "Okay, I'll tell you. Okay, I'll admit I killed her. I killed her. There, I killed her." Before retracting that comment a few moments later. You'll also hear, however, the defendant spoke with other individuals while in custody regarding this case. You'll hear what he was telling those inmates, that he was 100% sure that they would never find Vickie. Quote, "Where is she at? Is she missing?" The defendant replying, "No, she's dead." The other inmate asking, "Well, how do you know she's dead?" The defendant replying, "Oh, believe me, I know." Defendant commenting that there would be no blood or no teeth, that even if they did find her, they wouldn't be able to identify who it was. That is a summary of the evidence the state believes you'll hear over the next 2 weeks. For this, the defendant's charged with 4 offenses, which we read to you on Friday. First-degree intentional homicide, conspiracy to commit perjury, obstructing an officer. First-degree intentional homicide has 2 elements, just 2 elements. That the defendant caused the death of Vickie, that he intended to do so. Obstructing an officer, that he's misleading an investigation. Officers who are sworn law enforcement, giving them false information about this case. Counts 3 and 4, involving perjury. Again, testifying under oath about false information. Count 4 being the actual lying about it. Count 3, the conspiracy, means he worked with another person. He committed the crime with another person, and they did something to effectuate that purpose. So here, he's, as the state alleges, and you'll hear, the defendant conspired with Kathy Friday, his girlfriend, to commit perjury, to lie about the circumstances in which they met. Again, they're telling you why. They're aware of how that looks when his wife is missing. You'll hear from a number of witnesses over the next 2 weeks. And as we told you on Friday, they all provide essentially a piece to this puzzle. Sometimes the parties need to call witnesses out of order, there's scheduling issues, so you may kind of at a certain point not totally understand how this fits in when a witness is testifying. But once the testimony is over, you'll have a clear picture of what happened here. What happened on April 25th, 2013. You were just read a lot of law, and it's important to follow that. But really, at the end of the day, your job as a juror is to search for the truth. The truth of what happened to Vickie Prokopovitz on April 25th, 2013. The truth in this case is in the lies. The truth, if you carefully consider the evidence in this case, the state believes you'll find the truth in this case is that the defendant killed Vickie, and that he's guilty of all 4 charged offenses. Thank you.
Thank you very much, Attorney Saunders. Attorney DeAngelo, you ready to go for the opening?
Yes, Your Honor.
Go ahead.
Ladies and gentlemen of the jury, next time, no one will find me. That was a statement that Victoria Prokopovitz stated to her family the second time she tried to commit suicide. I'm going to state it again. Next time, no one will find me. I could sit up here and tell you that this was a perfect family. It wasn't. I could tell you that this family was full of love and happiness and there was always good times, but it wasn't. Was there good times? Absolutely. Every family has good times. Was there bad times? Absolutely. What the state has not told you is Victoria Prokopovitz has suffered from mental health issues since a teenager. She's been seeing a counselor since 1971. She was 18 years old. And she struggled with her mental health since that time. Since that time, she had been diagnosed with multiple personalities, where she had several different individuals. She was diagnosed with depression, anxiety, and there were suicide attempts. The state wants you to believe that my client murdered his wife because he wanted to get in a relationship with another woman. It's not true. The state wants you to believe that my client, at 68 years old, perfectly executed his wife's murder to the point that nobody can find her. You're not going to hear how it happened. You're not going to know when it happened. You're not going to have proof of a body. A 68-year-old man got rid of his wife, a grown woman, so perfectly that the house wasn't disturbed. My client opened up his house, he opened up his life to let the police search. The state's right. They did searches. They searched with dogs multiple times, even specialized dogs, cadaver dogs, looking for Victoria Prokopovitz. They searched with drones, sonar, individuals, family members, highly trained, specialized officers who do this. This is their job, their living, and they're good at their job. I got to believe they're good at their job, because they wouldn't be doing their job if they weren't good at it. And yet we sit here today with no body and no evidence of how she disappeared. They say my client was the only one that saw her before she disappeared. It's not exactly true. You're going to find out that James and Victoria lived with Victoria's son, Wesley. Wesley was there the day she disappeared. Wesley doesn't know what happened to her. Jim doesn't know what happened to her. The only person that knows what's happened to Victoria is Victoria. The problem with mental health is you never know when it's going to come on. You can have a good day, and just like that, it can change to a bad day. This is a missing persons case. Still is a missing persons case. Over the next several weeks, you're going to hear testimony from all these individuals that went looking for Victoria. They looked at quarries, they looked at sludge ponds, they looked at fields, they went down to the Mountain Bay Trail. They searched any and every lead they could get. If they heard it in a bar, they checked it out. Why? Because these guys are good at their job. They did not take a stone and not unturn it. If they heard it was up in a forest somewhere on mile marker 20, they went and looked. Why? Because she was missing. But they haven't found her. They want to get to the conclusion and then backfill how it works. Part of this is that Victoria's family doesn't like the way my client grieves. They don't like the fact that he didn't go on searches. Professionals were searching for her. Professionals with trained animals went looking for her. When they went on those searches, they went to the same places the professionals did. That's why he said, you're not going to find her. If the professionals can't find her, how do you think you're going to? This is a missing persons case. The state has the burden of proof in this case to prove beyond a reasonable doubt that my client killed his wife and he did it intentionally. You're going to hear about the night of the 25th into the 26th. You're going to hear that Jim got up like normal. He works at McKeefrey's, went to work that morning, went home to take his wife to a doctor's appointment. She went to see her psychiatrist that day. They drove home. He dropped her off, went back to work to check out his time card, went to Super Ron's, picked up some chicken at the deli, came home. Jim, Victoria, Wes, they all had dinner together. At some point, as the evening got on, Jim took his boots off, does what most truck drivers do, sat in his recliner and he fell asleep. That's the last time he saw Victoria, was when he went to sleep. At some point, Wes left the house, said he saw Jim laying on the couch or on the recliner, watching TV, possibly dozing off, and his mother was still in the kitchen. Then Wes was gone. And then when Jim woke up at 3 a.m., he went around the house looking for his wife. She wasn't there. He hollered for her, hollered for Wes, went outside, searched the property, couldn't find her. When he couldn't find her on the property, he got in his truck and started searching the roads. When he came back, Wes was coming in. Now, Wes, you're going to hear that he gave several statements to the police, just like my client. And Wes's stories weren't exactly consistent as to his time frame. But neither Wes nor Jim know where Victoria is. Now, the state wants to say, well, Jim didn't call the police right away, neither did Wes. Jim didn't call the family right away, neither did Wes. Jim didn't go on the searches, neither did Wes. Because Wes and Jim live with Victoria on a daily basis. They dealt with her mental issues on a daily basis. You're going to hear that both Victoria's two daughters didn't see her since November of 2012. They didn't go visit her. It's easy for somebody to come in and disagree of how the way you grieve when you don't live with somebody with mental health on a daily basis. Jim and Wesley lived with Victoria on a daily basis. Victoria tried to commit suicide for sure twice. You're going to hear about a garage incident where she tried to gas herself, where her daughters found her. You're going to hear about a pill overdose in 2002, right around Thanksgiving time, where their son Wes found her. That's when she said, next time, no one will find me. She was upset that they found her. You're also going to hear about another pill overdose in 2008. Now, that one, she said it wasn't a suicide attempt, but we're not 100% sure. You're also going to hear that she had cancer and that she struggled with it. It was getting better. It was colon cancer. She had a colostomy bag. It was reversed. But you're also going to find out that she wasn't as unable to move around as the state would have you to believe. In fact, she had the ability to go places. Wes lived with them. Wes had a car. Wes could take her anywhere she wanted to go. She could walk. She could move around. You would hear she used to putz around the yard, and she used to do it without her cane. Ladies and gentlemen, you're also going to hear about my client and that he met up with an old friend, Kathy Friday. Absolutely. But you're not going to have any evidence that he talked to her or dealt with her prior to Victoria missing. Why? He loved his wife. Still loves his wife. Everybody in this room wants to know where Victoria Prokopovitz is, including Jim. He wants to know where his wife is. We wouldn't be standing here today if we knew where she was. You wouldn't be necessary because we would know. The fact of the matter is there is no body, there is no evidence. She is gone. State has to prove that she's dead. No, Jim says she's dead. They're going to say, well, he talked to people while he's in custody. Well, of course, he's in custody. That was in 2019, 6 years later. Somebody says, what happened to your wife? Well, she passed. She's dead. It's been 6 years. She hasn't come back. It's an easy statement to make. It's also easy to interpret. I would love to tell you that this was the perfect family and everybody got along, but they didn't. But that's real life. This is real life. I can draw on, but I want you to look at the evidence as it comes in. I want you to take careful notes about timelines, time frames, and people's stories. I also want you to take careful note about how people turned on Jim because he wasn't grieving the way they wanted him to. You heard the state talk about how he wanted to get rid of her stuff. You're also going to hear that there was a telephone call in December of 2013, right around Christmas, where Jim told his stepdaughter, I just can't get rid of her stuff. And it shocked her. They want to make Jim sound like he is cold-hearted and did not love this woman, and that's not true. He loved this woman. He cared for this woman. He took her to doctor's appointments. They say that he was controlling. If your wife had overdosed on pills multiple times, wouldn't you lock them up so she'd stay safe? I would. That doesn't sound like a controlling husband. That sounds like a loving husband, trying to keep his wife alive. I leave you with this. Next time, no one will find me. Victoria's own words. Thank you.
One of the northeast sheds.
Is it common in your role in law enforcement that multiple pictures may be taken of the same thing from different vantage points?
Yes, take pictures from different perspectives so you can see where things are exactly. And
I'm showing what's been marked as State's Exhibit 20. Do you recognize this?
yes, when I pulled up into the farm property, it was clear to me that like some demolition had been going on. There was.
So what is 20 a photograph of?
20 is a photograph of the west side of the residence, I think. Or no, I'm sorry.
Let me show you Exhibit 21. Does that assist you in your orientation?
Yes, thank you. So 21 is a better picture for me, so I can see that the road is to the south of the house. And this is behind the house and the garage, and behind that garage is this downed bunch of rubble and beams, and like they're taking down like part of a barn.
So let's back up, then Exhibit 20 is a photograph of that.
Of
closer-
that pile, so looking from north of the residence towards the back of the residence.
And now I'm showing you Exhibit number 22. Do you recognize that?
And I believe this is the one open-ended shed that's to the north east of the residence. There's like some kind of tanker in one of the sheds, and then showing the large area of field behind.
Now, at the time, thank you very much. At the time that you are arriving at this residence, you indicated that, who did you speak with?
In the home, I spoke to Mr. Prokopovitz.
Okay. And when you're indicating Mr. Prokopovitz, I think you testified a little earlier, that's James Prokopovitz?
Yes,
Do you see the individual that you spoke with on that day here in the courtroom today?
yes, I do.
Could you briefly just point out where that individual is seated and what he is wearing?
He's seated at the defense table to my left. He's got a blue shirt on.
Do you have glasses?
No,
Let the record reflect the witness has identified the defendant, James Prokopovitz.
Mr. DeAngelo,
No objection.
then the record will reflect that. Thank you.
Now, at the time that you're arriving at the residence and meeting with Mr. Prokopovitz, where do you meet with him?
I spoke to him inside his residence.
Okay. So you did go inside the residence?
Yes,
Right. And at that time, were you the first responding officer, do you recall, or had others arrived?
I don't remember if the other guys were there yet, but
Okay. So when you arrive, you've already referred to this sheet that you would be filling out. Do you fill that out, or do you talk to him, or what do you do?
I always found it cold to like show up with a form in my hand when I go to talk to people, so I went and just talked to him first. But I know the forms, so I know the questions that are going to be on them.
Now, at the time that you are meeting with him, what does he tell you?
He told me, again, I asked him, what had happened, and he told me that he believed his wife to be suicidal and that she was missing. I asked, where she could be, or if she'd be with anyone, or if she could have taken a drive or gone anywhere. He told me that they didn't own a vehicle, and there was a truck out front, the blue truck, and he said that was his work truck. His employer owned that. He said that she commonly would go for long walks, and I asked if anybody else could have come and picked her up, or if she could have, called a relative or a friend, and he said that she really didn't speak to anybody and she really didn't have any friends.
Now, when you're talking to him about that vehicle that you just responded to, when you're asking him about access to a vehicle, he's essentially telling you she doesn't have access to one?
Correct.
Okay. And with regard to him making a reference to her being suicidal, was there an inquiry made about medication in the house?
Yes. I asked if she had any medication that she, would be taking. So it's a common question if someone's diabetic, and I know that they need medication. So asked if she was taking any medication, and he said she was. And I asked if I could see it because he had said she was suicidal. I thought, well, first I want to make sure this is not an exigent situation where she could have taken an overdose of her medication. At that point, he told me that he did not allow her to have access to her medication anymore, as he said she had made a suicide attempt, he told me 5 years prior by overdosing.
But he told you at that time that she did not have access to the medication,
Correct.
correct?
He told me that he keeps the medication and just doled it out to her as needed.
Okay,
And he showed me the bottles of medication, and they had the appropriate number of pills in them for.
okay. So nothing noted as missing.
Correct.
And he didn't tell you there were any missing.
No.
And he told you he's the one who had access to them.
Yes, he told me prior to that, because of the previous suicide attempt, he kept the pills and did not let her have access to them at all.
At the time that you're meeting with him, when he's already raised something pursuant to suicide, did you also ask him about the presence of any weapons?
Yes.
You recall what he said to that?
He told me that I believe that his son had one weapon, but he had already checked, and he and his son had already checked, and it was still in its usual spot. So at that time, I was kind of crossing things off my list that she could be using or doing harm to herself with in my mind. So there was no prescription medication of hers that she could be taking, and then no family weapons that she could have walked off with.
Now, based upon your training and experience, have you had experience with people who have been suicidal or attempted suicide?
Yes, ma'am.
In the case of a situation with respect to an overdose, would medications be important component of that?
Yes. So,
And now I'm seeing you're being told there's no access to that
correct.
and there's none missing.
Correct.
With respect to a suicide, have you also responded where there would have been a weapon involved as a mechanism for suicide?
Yes.
And in this case, now as you're responding, you're being advised there's none available or missing.
Correct.
Now, at the time that you're speaking with Mr. Prokopovitz, do you talk to him about the last time that his wife is seen?
Yes.
And I guess I should back up. When he's identifying his wife, did he indicate what her name was?
Victoria.
Victoria Prokopovitz?
Yes.
And what did he indicate with respect to when he last saw Victoria?
He told me that he had last talked to her 10 p.m. the night before.
And at that time, did he indicate what she was doing?
He said she was sitting in their living room watching TV, and he was going to bed.
Okay. And he said that was the evening before on April 25th of 2013?
Correct.
Ladies and gentlemen of the jury, now is the time to take the morning recess. We're seem to be segueing into another area. So if you would, everybody stand, please, and if you would go with bailiff Tom. Thank you. And this will be for approximately Thank you very much. Have a seat, everyone, and we'll get back together at 10:35. Thank you. Everybody, we're going to get started again. So everybody take their seats, please. And why don't you come back up here? Thank you. And you have your mask and all that? Okay. Yes, I see we have, that's better. Okay, let's stand for the jury and we'll bring the jury back out, please. Okay, have a seat, everyone. Thank you. And ladies and gentlemen of the jury, I trust your morning break went well. We'll break again sometime around noon for about an hour, and then we'll have a lunch break. Thank you. Ms. Lemko, go ahead.
Thank you, Your Honor. Now, Ms. Bilgo, we finished. You had just indicated that you were speaking with Mr. Prokopovitz about the last time he saw Victoria and what she was doing. You indicated that he said that he last saw her at 10 o'clock. She's watching TV. Did he indicate what he did?
He said that he went to sleep because he had to work the next day.
Okay. And then did he indicate that he had gone in the bedroom?
I don't recall where he went.
Okay. At some point then, did he indicate that he woke up?
For work and looked in on her and said that she wasn't in her bed.
Do you recall if he said he looked over and saw she's not in bed, or you just kind of don't recall?
No, my recollection is they didn't sleep in the same room because of the way he said that he looked in on her and that she wasn't in bed.
But if there was only one bedroom, then that is probably where he slept? You don't recall?
I don't recall.
Okay. Okay. So when you memorialize what you do in cases, do you prepare a police report? And in that to memorialize things so that if you ever get called to testify in a case, you may recall what occurred?
Yes,
Is it also utilized in the course of investigations then?
yes.
Would looking at your details and the verbiage used assist you? This happened a while ago.
Oh, yes. Yeah, this happened a decade ago.
Been marked as exhibit number 26. What is this?
It is my
Do you have the opportunity to briefly review that before testifying here today?
I did.
Okay. Now, specifically with regard to your report, when you're indicating what Mr. Prokopovitz indicated had occurred on that date, and now I'm looking specifically in paragraph He indicated that when he went to bed last night, after that, would that indicate he had gone into another room and not been sitting in that same?
It was a small house, and now that I asked when he had last seen her, and he had said when he had went to bed, she was watching, and that when he woke, she was not in bed.
Okay. At that time that he is talking to you about that, did he indicate that initially that wouldn't have been uncommon based on their sleeping habits?
He did. So, and I thought that was odd because, she's up later, he goes to bed because he has to get up early, but then he said that she often got up before him yet and would go for walks outside.
When he referred to the fact that she'd go for walks, do you recall if he indicated she recently would or that, or don't you know?
I just remember him saying that, because I was kind of, when he said that he woke up and she wasn't there, and I was like, oh, my goodness, that kind of seemed, and he said, no, that was common, that she would often get up at, when it's still dark and go for walks.
Okay,
And I thought that was just a bit odd also.
but that's what he said.
That is what he said.
So at the time that you're speaking with him, do you also, in particular in today's day and age, ask him about whether she had internet access?
Yes, because she was just,
About her pattern, somebody that was frequently in her house?
as far as like
His
her,
description of her.
he told me that she had had a colostomy bag for a significant amount of time, and that because of that, it produced a significant amount of anxiety for her, just having to have that under her clothes. Didn't socialize much,
That she wasn't leaving the house much.
correct?
At the time when you're talking to him, did he indicate if she had any internet access?
Yeah, I specifically asked about internet, just in case she was talking to somebody or got a ride a different way, because he had given information that her at the house, I was just trying to contact someone.
When you're talking about this phone, did he actually show you the? Did he indicate what else she had left behind?
So she took a peek in it to see what all was in it. And there was actually, her money was still in it, her driver's license, IDs are still in it, her makeup, things were still in there. So to me, that indicated that a member or friend or something, or just to go for a drive or something, you're going to take your purse, your personal identification, phone, and your money. But all these things were still there.
Now, with respect to these, showing you it's marked as State's Exhibit number 27. What is this?
A small woman's handbag.
Does this appear consistent with the purse you saw on that day?
Yes.
I'm also showing you exhibit number 28. What is this?
Flip phone.
And based upon your knowledge of flip phones back then, would that have been something that had access to an internet? Or don't you know?
That one, 10 years ago, probably not. I don't.
When the defendant told you, Mr. Prokopovitz told you.
He said that she did not have internet access.
Now, at the time that you're there, when you're talking about that purse, was the purse opened?
I had definitely opened it and took a look through it, looking for anything that would indicate maybe where she was, an appointment card.
So I'm showing you, so the record reflects, Your Honor, I have opened exhibit number 27. As I'm opening this up to you, does this appear to be consistent with all the personal items that you would have seen on that day?
Yes.
Does it appear to be pretty full?
Yes.
So this isn't an item that it seems most of the belongings are missing. There's things in it.
Yes.
Okay. And consistent with that, do they appear to be personal?
Yes. Hairbrush, comb, makeup.
A lot of it makeup? Is there perfume in
Yeah, it
there?
looks like makeup and she's even got a sandwich baggie of other. Kind of like waited for me to ask my next question, or like he just kind of stood there waiting for me to tell him what was going to happen or what I was going to do.
And when you arrive on the scene, you're already receiving some information about the comments he's making when he would have called dispatch. Is that right?
Yes. So yes,
I was going to say, is that something that gets put in what's deemed a CAD report?
yes.
What is a CAD report?
It's the initial computer notes that our dispatch center gets. So someone in the dispatch center answers the phone. They ask you who you are, what's going on, and where you are, phone number, personal information. They put it in, and they'll put in statements that the caller gives them. So our CAD notes would give us our first, as an officer, give us our first look at what someone is calling in for assistance with.
And that's what I was going to ask. So that when you're coming out as a law enforcement officer, the CAD notes are what you rely on having some preliminary information about what's happened.
Yes, ma'am.
Been marked as state's exhibit number 24. What is this?
It is a printout from the Brown County Sheriff's Department CAD computer, and it's basically just the timeline, each item as they enter it into the computer.
Now, with respect to that, is the title on that also incident recall?
Yes,
So that's something that's memorialized about an incident?
yes.
Specifically, I would ask, in relation to this incident, if starting with Victoria Prokopovitz, down to the end of that paragraph, if you could just read into the microphone for the jury what was said.
So this was what I mentioned before when I got the call, and they give us so much verbalization of the call over the radio, and then we look in the computers. So this is what I would have read. It says Victoria L. Prokopovitz, 9/10/53, female white, 60 years of age, has been missing all morning. Complainant husband woke up for work early a.m. but then has been looking around after an hour or two. So he went in search of her and cannot find her, called his son, and they have been out looking and cannot find her. Her purse, phone, and items she would normally have are home. She suffers from depression and was to see her doctor yesterday with husband at Bellin and seemed to go well, changed her meds, ? But call her husband was with, and she seems fine.
So with respect to that, at the initial call that you're responding to, the caller has said, who's identified as Mr. Prokopovitz, that the appointment, that she seemed well. Is that right? On that day?
Yep, this is information that dispatch is putting in, and they would have got that from him as the complainant, and that, yes, he said he told the dispatchers that she seemed fine.
He said the appointment, she seemed well, and that she seemed fine.
Yes,
Both things.
yeah, more than once he told dispatch that she was.
So at the time that you were speaking to Mr. Prokopovitz, you found out that it has been indicated that he and his son have been out looking. Is that right?
That's what dispatch had relayed to me.
That's what he said, right? Well, that's what dispatch said, he said.
Yes.
Okay. So when you're speaking with him now, you indicated that you were making an inquiry about access to medications, to weapons. As you're on the scene, you've been indicated that there's nothing with respect to that going on. Is that right?
Correct.
When he's indicating that he woke up now and
That she wasn't in bed.
yeah, so then he indicated, did he indicate then what he did?
He told me that he was worried and actually drove around in his work truck looking for her for a while before he went to work.
Okay. And then did he indicate where he worked?
He did. It was Georgia Pacific. He worked for McKeefrey, and they were contracted through Georgia Pacific.
Okay. Now, when you're speaking to him, do you make an inquiry as to what Victoria was last wearing when he last saw her?
Yes.
And what did he say?
So again, with a missing person, let's say it's even a teen, or like, what are they last wearing? First of all, we're wondering if it's appropriate for the weather. Are they out in, shorts and it's 30 degrees out? So I asked him if he had any idea what she might be wearing, and he didn't really have any suggestions. And I said, well, you said that she normally walks. So does she walk, like have a certain pair of shoes that she goes for walks in? And I don't recall if I suggested it or if he said that she possibly had some white tennis shoes. All the things in the home that I could see from standing in the kitchen, the small dinette area, it seemed that everything had a place. So there were a lot of like knickknacks and keepsakes and things everywhere, but everything was placed. I asked if she kept her shoe wear somewhere, or her whatever shoes or boots she had, and I kind of walked a little bit in the dining entryway where you come into the house, and I moved enough that I could kind of see into what appeared to be a bedroom. And there didn't seem to be a lot of space around it. And Mr. Prokopovitz said, oh, she doesn't keep her shoes in there, indicating the bedroom. And I'm like, well, where does she keep them? You know, maybe it'll be obvious to you if we look. So then he indicated behind where I was, south of where I was, there's a really narrow hall, and there was a very shallow closet. So we look into the closet, and very neatly are shoes and taller boots in like a second or third row. And all the front row was full, but a back row item was missing. And I'm like, well, are these her shoes? He's like, yes, those are all her tennies. And I'm like, well, what seems to be missing? He's like, well, there's a boot missing. I'm like, okay, what kind of boot? And he said it was a dressy, high stacked heel boot. And I'm like, how high? This high, this high. So he indicates, you know, really high stacked heel boot. I'm like, okay. And I'm thinking to myself, when he's indicating that this is what she's wearing to go, you know, middle of the night, dark 30, 4 o'clock in the morning, go for a walk, I thought, this is hinky, because being a woman, I'm not going to want to walk around outside in a stacked heel boot.
Well, let me ask you that. When Mr. Prokopovitz had indicated to you
Asked him what she normally would wear. I don't recall if he had said that she normally would wear the tie, or if I had offered that up as.
So at the time that you were talking to him, as a law enforcement officer, is it important for you to evaluate the plausibility of the information you're getting?
Absolutely.
Okay. And with respect to that information, that caused you to pause?
It did.
Okay. Now, besides indicating that she had been wearing a particular shoe, did he also indicate to you anything relative, just what he said about what clothing he was last seen in by him?
So after the boot indication, it was very clear that something was missing from the back like that. I was kind of more interested in like, okay, what was she last wearing? And he didn't seem to want to postulate to what. So I said, well, is there a certain place she keeps her coats? How many coats can she have? I said, let's go looking where you keep your coats. So in the little bit of an entry, we backtracked through the little dining area. There was like a hall upper coat area. And so he opened that up and I'm like, okay, here's her coats. What's missing? And he said that her white coat was missing.
Okay. So essentially, the description you had at that point then is that when you made an inquiry of him, if her purse was missing and he told you no, it wasn't, and showed you that?
Mhm. Yes, ma'am.
Now, as you are talking to him about the items that were still left behind, isn't it true that her driver's license had been left behind?
Yes,
But you already have information she didn't really have access to have left in a car anyway. Is that right?
correct.
When you're talking about this house, you made a reference in your testimony about it being small. Is that right?
Yes, yes, ma'am.
When you're describing that, if you were to learn that the defendant, or that there were statements about everybody being able to hear what was going on in the house, would that surprise you?
No,
Okay. And when you, just so the jury understands, I know the pictures we're going to publish will show it. Was this like a 2-story house,
yes,
recall? And was there a basement?
there was.
Okay. Besides the driver's license, was her social security card also left behind? If you recall.
I don't recall.
Okay.
I believe if I had looked through her purse, I would have looked completely through it. And earlier when you held the purse up, you opened the larger compartment on it. I believe if you open one of the side compartments, because I didn't notice the driver's license in the middle, and possibly in one of the side compartments and some other ID.
Okay, so I'm, again, just for the record, showing you Exhibit 27. I'll touch it. You don't have to open this.
So now in this smaller side pocket, because I can, is there money in there? Because I remember noting that there was like $10 or something in her wallet. Mhm.
Okay. As I'm taking, is this the side pocket here then of 27?
Yes, it's
Okay, and what would this first item be out of the side pocket?
a Wisconsin driver's license issued to Victoria L. Prokopovitz.
Okay. What would that be?
It looks like a health card. And a social security card for Victoria Lynn Prokopovitz. A laminated picture of Jesus.
Okay, would this be what some call a prayer card?
And you turn it over and it says, yes, there's a don't quit prayer message on the
Can you
back.
say that into the microphone? What's the title of that?
The prayer card she keeps with her license, it says don't quit. Medicare piece of paper in her wallet to Victoria for just,
The beneficiary's her.
yes,
But again, another item of medical benefits or care, Medicare.
yes, that I would assume that a person would keep in their personal.
Piece of paper.
Yep.
What is that?
A little piece of paper from in her wallet that says PIN number 1006.
actually, in law enforcement, when there is money located in an item, that's usually put in a separate class for currency.
Are you asking me if
That
people,
money actually-
people keep money in different spots?
One at a time. One at
Sorry.
a time, please.
Sorry.
Thank you.
No, once a piece of evidence goes to law enforcement that is money, that gets separated and put in a different account because it's money?
Yes.
Okay, that's what I meant, sorry. So actually, in this case, at the time that you see the purse, but it's not actually taken into custody.
No.
Okay, so when you saw the purse, there was a $10 bill in it?
Yes.
So you actually don't know what happened with the money that was in there?
No.
Okay. Now, at the time that you were speaking with Mr. Prokopovitz, at some point, you make an inquiry about whether or not other family members have seen Victoria.
I asked specifically, as her cell phone was laying on the table with the purse, I asked if she had been in contact with any friends or family. And Mr. Prokopovitz had said no. When he had told me that that was her cell phone on the table, I remember asking him if I can't remember if I was worried it would have a pin or something, but I think I just opened up the phone and looked to see if she had any exiting calls or any incoming calls that she would have had either on the 26th or the night before, indicating where she could be.
And as a result of that, and I'd ask, I think, do you have your details up there still?
Yes, ma'am.
I'm looking now on the bottom of page one of your details. Would looking at that refresh your recollection quickly about what you did with the phone?
Yes. When I did open the phone and check it, it showed no calls in or out since the 20th. And this was the 26th.
So the 20th would have been 6 days earlier.
Yes.
And you noted that? No calls in or out?
Yes. I thought it was odd, especially because Mr. Prokopovitz said that he had looked for her that morning before he went to work, indicating that he must be somewhat worried about her, but that he didn't call her. No one called her like during the day to check on her, and that he didn't try calling her after work to speak to her.
So at the time also then, when you're quickly checking that history, you stated you noted most of the calls were to or from Jim's cell?
It did. So in looking at it, most of the calls were just back and forth between her and Jim prior, 5-6 days prior to the day that I was there. But I did notice one call from a Stacy in the history. And I asked who that would have been, and Mr. Prokopovitz told me that it was Victoria's daughter. And I had asked if he had checked with Stacy, and he said that he had not. And I thought I recalled, at that time, I thought I recalled him telling dispatch that he had checked with people. to see where if she could be with a family member. So I thought that that was odd. So what I did was I made a conscious choice to call Stacy from Mrs. Prokopovitz's phone, not from my work phone, but from her phone. Many times people will answer the phone if they recognize the number. So I called her and spoke with Stacy.
And at the time, did she identify herself and give you her full name?
Yes,
What was that?
Stacy Deer.
Okay. At the time that you are calling Stacy, you now know you're calling her, and Jim's already told you that he hadn't told her about her mom?
Correct.
So when you call Stacy, do you make an inquiry about when she last spoke to her mom?
I did. Stacy told me that she hadn't spoken to her mother for a week, but she did indicate that their phones had been off. When she said off, I assumed not connected, not paid for. So she hadn't been able to contact her because of that. And then she said they had recently been turned back on. I told her that, obviously I was a deputy with the sheriff's department and that I was at her mother's residence because Mr. Prokopovitz had called the sheriff's department worried that Victoria had not been heard from since possibly the night before. And Stacy told me that she was concerned.
And did she tell you why she was concerned?
Stacy indicated that her mom had tried to harm herself to commit suicide several years prior by taking an overdose, and that Victoria had made a comment to Stacy if she ever did try to kill herself again, that she knew of a place where nobody would find her body.
So at the time that you're hearing that, that's just a fact initially in the case with regard to concerns about the mental health about Victoria and the possibility of suicide. Is that right?
Yes, ma'am.
So as a law enforcement officer, you're attempting to collect all the evidence involved in cases. Is that right?
Absolutely.
And at the time that you're investigating this as a missing person, you are acknowledging that you're dealing with someone who's had a history of depression and suicide. Is that right?
Yes, ma'am.
So as a result of that, and in speaking to Jim, did you learn that there was another occupant of the house that he was living in with Victoria?
Yes. Jim told me that Victoria's son, Wes Edges, lived with them. And I asked where he was. I asked where he was for a couple of reasons. I don't want to be in a house where there's people and I can't see them. I don't know them or their intentions. But I had been there for a little while talking to Jim, and I hadn't heard anything or anyone. And when I went to the house and dispatch had given me those initial CAD notes where it said that he and his son, Wes, had been looking for her, when I arrived and went into the home, I assumed that I would be finding numerous family members there who were frantic, concerned, looking for this 60-year-old woman. And when I got there and there was only Jim and he was really calm, it seemed odd. So when he said that Wes was actually upstairs, it made me think, well, why would he not be downstairs talking to the police officer that's in their house?
And so as a result of hearing about Wes, did Wes then come down and talk to you as well?
I think I asked Jim to get him or something from upstairs, and he got him, and Wes did come downstairs and talk to me.
And at that time, did Wes tell you he was very worried about his mother?
Actually, the opposite. Wes told me that he had seen his mom the night before at around 6 p.m., but he thought his mom seemed fine.
Okay, but I'm talking about when Wes came downstairs, now with her being missing. Did he indicate he was worried about her being missing?
I don't know if I put anything, I don't recall Wes.
I'm looking at your details in the third paragraph. Would that refresh your
Yes.
recollection?
Yes, that when Wes came downstairs, he told me that he was worried about his mother.
And so what you're testifying to is you made an inquiry of how she was the last time he saw her?
Yes,
Okay. And does Wes tell you the last time he saw his mom?
yes, he said that the last time he had seen her was the night before, around 6 p.m. And I asked, well, was she acting depressed or odd? And he said, no, that she was in a good mood, and he specifically said she did not seem depressed.
Okay. So with respect to the information you got about prior suicide attempt or a statement Vickie made, you were never given a context of when that happened. Is that right? You don't know when she said it? When she made that reference to Stacy?
No, I don't know.
So if it was 10 years earlier, you didn't know that on that date?
No,
Okay. You've just heard that phrase.
yes,
But all the information you're receiving on that date from Mr. Prokopovitz and Wes is that Victoria, when last seen, was in a good mood and not depressed.
yes.
Okay. At the time that you're there, then meeting with him, and now I'm talking about Jim again and Wes, do you have the opportunity to look at the rest of the house?
Yes. I asked Jim to walk me through the whole of the downstairs, kind of describe things and look with me, looking for anything that would be out of place, whether something was missing or broken or anything. He actually took me downstairs to the basement. The basement was decorated very detailed in a Christmas theme. It had Christmas trees up, all Christmas decorations. And then it was basically one big kind of room in there, but it was a small basement. And off to one side, it was actually like a field stone stacked, dry stacked basement on the one side. So it was a little creepy.
So at the time that you're down there, nothing is pointed out that's broken or disheveled?
No, and the way Wes had stayed upstairs and not come down to talk to me, I thought maybe Wes didn't want to be down by me. Maybe he didn't want to, because sometimes people just don't want to see the police officers. They have other issues in their lives and they don't feel comfortable around us. And I remember when I was looking through the house, because I was getting an uneasy feeling from both men, that as police officers, we're always looking for things out of place or, blood spatter, things we're always looking for, some horrible things are waiting for horrible things to happen. It is what we're trained to do.
And at that time, you didn't note any?
No,
Okay. So besides that, and you had never met Wes or Jim prior this date?
no, not that I,
So you didn't really know their history or their background and?
no.
Okay. So now, at the time, when you're meeting with Jim, however, he did indicate that Victoria had recently had a surgery that caused her to have a colostomy bag. Is that right?
When I was asking about her state of mind and the medication, I believe he told me then that because she had had a colostomy bag for some time, that led to her developing her extreme isolation because she didn't feel comfortable going out and about with it. But I believe he had said that she had a reversal surgery to remove the bag more recently.
Okay. But he did concede she had had some anxiety over the months with that colostomy bag?
Yes,
Okay. As a result then of meeting with him, you already referred to the fact it's typical that you'd fill out a missing person report, is that right?
yes.
Okay. I'm showing you what's been marked as State's Exhibit 25. Do you recognize that?
Yes, it's a Brown County Sheriff's Office missing persons certification. It's got the 13-18599 incident for this case, and it looks like my handwriting that I filled it out and had James M. Prokopovitz sign it.
Okay, and your name or your signature is on that document,
Yes,
as is Mr. Prokopovitz's?
yes,
And the name of the missing person's Victoria Prokopovitz?
yes, ma'am.
And just so it's clear for the jury, this Exhibit 25, this actually is literally a form that gets filled out for a missing person?
Yes,
Okay. And again, that's because this is actually more standard than typical. This is more common than people may know. That's why you have a form to just fill out when someone's missing.
yes,
Okay. And here's what I mean by that. When you're an officer responding on an allegation of a missing person, this isn't something that officers just go in and start for a missing person, executing search warrants and doing all of this with evidentiary value, because sometimes people are recovered, correct?
majority of time people are recovered.
And when they are recovered, it's typically in short time.
Yes, ma'am.
Okay. And again, then you're following the standard protocol that you would have done on that date.
Yes,
So as far as you not collecting a purse or not doing some other different things on that date, starting an investigation to look for Victoria.
correct.
The time are, however, at the time you are there, you do call in for some assistance. Is that right?
I did. I believe that I called at least two people on my way out to the call, knowing the area, knowing how big it would be. One being a canine officer and the other being my shift sergeant, letting him know, like, it was towards the end of my workday, and knowing the area was so big, I was hoping I could get at least another person out there to help look around the property in case she had walked out by one of the many barns and fallen down, or maybe gone out in one of the barns and hung herself.
And with respect to that and your agency, because it is getting towards the end of your shift, are you also calling someone into backup to cover your shift should it go on? Because overtime can be an issue and sometimes it's not granted.
Yes,
Okay, so you're calling a backup person and you're saying that's Deputy or would be Sergeant Rick Kurth on that date?
yes, on that day, he was the shift supervisor for the section I was working, and he was actually going to work overtime for in coming up afternoon shift.
And then you've also indicated that you had called Officer Merle Cornelius as an assist from Oneida on the canine.
Yes,
With regard to both of these gentlemen being contacted by you, did they then arrive at the residence?
yes,
And you're still there when they're arriving?
I
You remember?
I believe they might have arrived even before I walked in to speak to Mr. Prokopovitz. I don't remember if they were both there or if just one of them was there.
You just know at some point, all three of you are there, no?
Yes,
All right.
but The other two officers utilizing the canine. When you utilize a canine for a search, you have one officer with the dog, and then you have a second officer always who is with them, because the officer with the dog is looking at the dog. So he's not looking at his surroundings, he's not looking for bad people with guns, or he may miss something. So we always have a second officer that walks with him.
So at the time that the officers arrive, do they search a different area of the residence than you do, or the outlying
They-
areas?
I had directed them to search the outbuildings in the field, and then possibly the wood line for her.
When you arrive, you made mention of something, is there this burn barrel that's there at the residence?
Yes, I recall, like, I drove in the driveway, and when we park, we don't drive up to someone's house and park right up to the house or right up to their garage. We park off tactically, because we never know what we're coming to. So I had parked to the northeast of the residence, and there had been, I think there's more than one burn barrel on the property, but there had been a burn barrel by the front of the house, and then maybe another, I believe another burn barrel behind the house. And I believe that the front burn barrel was actually smoking or burning when I arrived.
You know if that second burn barrel in back may have been like a dumpster, or do you think it was a second burn barrel?
No, I don't know what was in it. I didn't go out back or look at anything back there. I just know there was another barrel for sure back there.
Do you also remember when you were at the residence, do you remember seeing Mr. Prokopovitz's truck? Was that pointed out to you on that date?
I believe so when we drive into a driveway, we don't want to be surprised by anyone that's there. So it's not indicated in my call notes, but I'm sure I ran the plate of the vehicle, and it would not have come back to Mr. Prokopovitz because it's not, he told me it was owned by the company he worked for. But yes, there was a blue pickup, I believe.
And you wouldn't recall the condition it was in at that time?
Other than looking at some of those pictures that you had of